in court. My name is Heather, and this is, as you could see from the thumbnail, episode 18. Judge Cannone has it all wrong. We are going to go over in this episode. So this is the Commonwealth of Massachusetts versus Karen Reed. We're going to go over the Memorandum of Decision and Order on defendant's motion to dismiss. So the defendants put forth a motion to dismiss the case for many reasons, citing misconduct, citing third-party culpability, all this other stuff. And, hiding evidence, planting evidence, all the stuff that's going on in this case, as most of you probably already know. If you don't, I recommend you go back to episode 1 because I can't fill you in on everything up until now in one episode. But anyways, so we are going to read this. The defendants put forth the motion to dismiss for many reasons, and I thought it was great. I didn't feel, and I was with a lot of people that didn't feel that this case was ever going to go to trial because of how much has come out now that we know that implicates other people and exculpates Karen Reed. So that hasn't happened. We just had a hearing this week, Karen Reed did, with Judge Cannone, and it appears we're moving forward with an April 16th trial. We are about 3 weeks away, a little less than 3 weeks away now. And so it's happening April 16th. So, it's happening because she denied their motion. So, on June 9th, 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of unaliving in the second-degree manslaughter while operating under the influence of alcohol and leaving the scene of a crime, or leaving the scene of personal injury and or unaliving following the unaliving of her boyfriend, John. It sounds so stupid to say unaliving, but it is what it is. Or you have to spell out, his life was ended. All right, so John O'Keefe, who they don't even mention as a Boston police officer here, her boyfriend, John O'Keefe, on January 29th, 2022. So the defendant is pursuing a third-party culprit defense, arguing that one or more persons attending a social gathering at the home of Boston police officer, he gets the title Boston police officer, Brian Albert. Why is nobody outraged by a fallen Boston police officer in front of another Boston police officer's home? I mean, the people of Canton are outraged. The government doesn't seem to give a crap. So anyways, let's move on. So the defendant's pursuing a third-party culprit defense, saying it was somebody attending the social gathering at the home of Brian Albert on the 29th, and that they, along with others, including the Canton and state police, engaged in a cover-up of the crime. Yes, they did. The proof is in the evidence. The defendant now moves to dismiss the indictments against her on the grounds that the Commonwealth's presentation of evidence impaired the integrity of the grand jury proceedings. See Commonwealth versus Odell. That is another case that they keep citing. So she argues that's the case that they're going to keep citing probably throughout. So she argues that the Commonwealth knowingly and recklessly presented false and deceptive evidence to the grand jury and withheld exculpatory evidence for the purpose of obtaining the indictments. And yes, they did, Judge Cannone. They absolutely did. The defendant also argues that the Commonwealth deliberately admitted inadmissible evidence to secure the indictments. Probably. They probably did. They're very dirty, underhanded, corrupt people. And maybe you are too, Judge Cannone. On March 12th, 2024, the court conducted a non-evidentiary hearing on the defendant's motion to dismiss. The court has carefully reviewed all the grand jury minutes and considered each of the defendant's arguments. Given the extensive evidence supporting the indictments, to the extent that the Commonwealth improperly put before or withheld any evidence from the grand jury, it is unlikely that it affected the outcome of the proceedings. Accordingly, the defendant's motion is denied. So, okay. The extensive evidence supporting the indictments. And she doesn't think that anything that the Commonwealth did was improper that they put forth in front of the grand jury. And even if they did, it's unlikely that it affected the outcome. All right, so this is a little background in Cannone's words. So a lot of it's going to be incorrect. Or inaccurate, I should say. So during the grand jury proceedings, the Commonwealth presented evidence of the following, and we'll go down here to the footnote. The grand jury heard 14 days, so 2 weeks of testimony from over 40 witnesses and received 56 exhibits. This background section is merely a summary of the Commonwealth's grand jury presentation and is not intended to reflect the entirety of the evidence it presented. The discussion of certain evidence has been reserved for the analysis below. Okay. So on the night of January 28th, 2022, the defendant, O'Keefe, and a group of friends went to the Waterfall Bar and Grill in Canton, where the defendant consumed several alcoholic beverages. But you know what? It wasn't just the defendant that was consuming alcoholic beverages. It was everybody there. So the McCabe's, the Alberts, all of them went home, drove home with a little liquid courage in their blood. So, and Karen may have too, but that doesn't necessarily mean that she ended John's life. Anyways, so shortly after midnight on the 29th, she drove O'Keefe to the home of Boston police officer Brian Albert, the Albert residence, where a group of people from the bar were meeting. Early in the morning, on January 29th, 2022, a heavy snow was falling with blizzard-like conditions. At 4:53 a.m., O'Keefe's niece called Jennifer McCabe, a friend of O'Keefe's, and told her that she needed to talk to the defendant. It was the defendant who wanted to talk to Jen McCabe. So I think Cannone's got this a little bit wrong. The defendant, Karen Reed, woke up the niece because at 5 in the morning, John still wasn't home. She was frantic. She was worried. At this point, she was very upset. Very upset. So she awakes the niece and tries to get her to call Jen McCabe because she didn't even have the number. So the niece calls Jen and then they start talking. Have you seen John? Blah, blah, blah. So that's how that goes. All right. So, but not that the niece just called out of nowhere. It was because Karen Reed was frantic, wanting to know where John was. She was upset her boyfriend wasn't home. She was worried at this point in time. So there you have it. Jennifer McCabe had been at the bar with the defendant and O'Keefe the night before and went to the Albert residence afterwards. The defendant was distraught. That's a good word to describe it. The defendant was distraught because O'Keefe had not come home yet. So that's good that the judge is acknowledging her emotional condition right now. And he was not answering his cell phone. Jen McCabe heard the defendant screaming, "John didn't come home. We had a fight. I left him at the waterfall." And remember, this is coming from Jen McCabe's words, who we're supposed to believe because why? She's the one that Googled how's long to die in cold. But this is from her grand jury transcript. She said this in the grand jury, that Karen was screaming, "John didn't come home. We had a fight. I left him at the waterfall." That's coming from Jen. And around 5 a.m., the defendant called Carrie Roberts, whose husband is friends with O'Keefe. The defendant was, quote, hysterical, and she screamed, "John's not alive," end quote, and then hung up. That also seems a little sus. So she called Roberts back and told her that O'Keefe had not come home. During their conversation, she stated, quote, Something must have happened to him. What if he's not alive? What if a plow hit him? End quote. The defendant also stated, I don't remember anything from last night. We drank so much, I don't remember anything. Give me a break. Okay. So who, the defendant also stated that. Who said she stated that? Who said that? And where's that coming from? Cannone didn't cite it. So I wonder who said that. All right, the defendant McCabe and Roberts went to look for O'Keefe together at the Albert residence. While on their way, the defendant wondered out loud whether she could have hit O'Keefe with her car and mentioned she had a crack in her taillight. I doubt it was exactly like that. And you know that she's been sitting in cars and talking to Jen McCabe and Carrie for quite a while now, driving around looking for John. So don't you think they might have gotten into her head? If they're supposed to be, you know, playing this out like, you know, McCabe is in on this, because she obviously is. So we're just supposed to believe that McCabe didn't have any influence on anything that Karen may have said, or that she's lying about statements that Karen said. We're supposed to believe her. So while on their way, the defendant wondered out loud about that. Okay, so shortly after 6 a.m. on the 29th, they arrived at the Albert residence, where the defendant spotted O'Keefe lying in the front yard covered in snow and unresponsive. When the paramedics arrived and asked what happened, the defendant, who was hysterical and inconsolable, repeatedly stated, I hit him, I hit him. But at this point in time, she was freaking out. She had just been doing CPR. She just saw her boyfriend in this badly beat up condition. And I will say beat up because he was beat up not by an SUV, but by a human and a dog. So she, of course, she's going to be frantic and hysterical at this point. And if she's saying, I hit him, she might have been, you know, thinking she must have done something, because these thoughts must have been planted in her head from Jen McCabe and what's her face, or she was worried that she did something, but she knew she didn't. She was just in that state of shock. So the paramedics transported O'Keefe to the hospital, where he was pronounced not alive anymore. The medical examiner ruled his cause of not being alive as blunt impact injuries of the head and hypothermia. So he had blunt force impact injuries on his head. We know he had like at least a 2-inch gash on the back of his head, and his whatever it is that they test, it was his pancreas or something turned a different color. I can't remember what it is, but whatever it is, it was a sign that he was experiencing hypothermia. So it's a good possibility that if he had been brought to a medical facility or had some medical attention right away, he might have survived. It's good. It's decent to say that, because hypothermia is one of the causes. So not just the head injury, but that comes from whoever hit him inside. So she did not see any obvious signs of an altercation or a fight. The medical examiner. Really? Did I skip something? Oh yeah, the paramedics transported O'Keefe to the hospital, where he was pronounced alive. I did say that. Blunt force injuries, and I was right. Okay, she did not see any, quote, obvious signs of an altercation or a fight, which is BS, because as we all know and have seen the autopsy photos of John O'Keefe, he has 2 very bad black eyes, a lot of swelling in his face, bruising, puffiness, and his hand, his knuckles, right where you would punch someone, right in here, was all bruised up. They took pictures of it. All bruised, like he got into a fight. And then, of course, the dog bites on his arm. So how can you say there was no altercation or a fight? I don't understand that. During the subsequent police investigation, officers discovered pieces of a taillight and a broken cocktail glass at the scene. They seized the defendant's vehicle, which had a shattered rear taillight and scratches on the bumper. And I don't believe that that is correct. Now she's making more stuff up. So it went from cracked to shattered and missing pieces to now it's shattered rear taillight and scratches on the bumper, which that is not corroborated. That's not true, Judge Cannone. Get your facts straight. A forensic toxicologist opined that the defendant's blood alcohol level around 12:45 a.m. on January 29th, 2022 would have been between 0.13% and 0.29%. And this is because the defendant's BLOOD was drawn at Good Samaritan Medical Center, where she was taken after O'Keefe's body was discovered. So she was taken in the morning and, afterwards, and they did a test on her for her alcohol BLOOD level. And this person, so whatever her reading was at that moment in the morning, she did have some in her system still. But he said that whatever that reading was, he had to do some kind of calculation to make it work backwards in time. So she's getting her blood drawn at like 7, 8 in the morning. And she is supposed to have hit him at midnight-ish, 12:30. So I don't know how you can accurately come up with a percentage there, in my opinion. And such a high and such a big differential between the two. So how do you even get that? That's just crazy to me. They're forensic toxicologist. Whatever. All right, so police officers spoke with the people who were present at the Albert residence, who all reported that they did not see O'Keefe and he never entered the residence. So Judge Cannone is buying that bullshit that nobody saw John O'Keefe come into the home. Okay. The Norfolk Advocates for Children interviewed O'Keefe's niece and nephew who lived with him. And I want to preface this before we get into what they said. They, the children, were underage, number one. Number two, there had been like a span of a month at least between when John's body was found and when the kids were interviewed. So when they were interviewed, there was plenty of time in between in which someone could have corrupted their statements. And we know this to be something of a trend that the McCabe's and the Alberts do to glom people onto their side. They probably I don't know what it is about these people, because there's no way I would want to be friends with them, but something about them, I don't know, maybe they have dirt on people. I have no idea, but people want to protect them. They want to help them. So, and they are, if they don't have much of a brain of their own, they are persuaded by what the McCabe's say. And I'm saying this because his niece and nephew were underage children, and it is very, very, very likely that the McCabe's and the Alberts got to these kids beforehand. And I'm not saying that anything that they said is not true, but I'm just prefacing it by saying that. And that's what I'm going to say, because we know that the McCabe's and the Alberts have a pattern of trying to get people on their side. Come on over to the dark side. And I think that's what they did. That's what they did with the O'Keefe family. And that's, I believe, what they did with the niece and nephew. But I don't know for sure. This is things that I've kind of heard and speculation and whatnot. So I can't say for sure. But that's my opinion. All right, so they stated that the defendant and O'Keefe argued frequently. They both described a recent argument within 2 weeks of O'Keefe's not being alive anymore, where He had asked the defendant to leave his house, but she refused to leave. O'Keefe's niece described a second argument within a week of his being not alive, where she heard O'Keefe tell the defendant that he wanted to end the relationship, that it had run its course, that it was not healthy, and that they argued too often. First of all, I just want to say those are not words of children. That it had run its course, that it was not healthy, and that they argued too often. I mean, that they might say like they fought a lot, but these are kids. They're not going to put it into those terms. They don't know. They don't have the adult relationship skills that we do, and the ability to phrase things like that, in my opinion. And I think that these were fed to them, these ideas, because in a traumatic situation, when your brain is traumatized, when your body, brain, whatever is traumatized at some point in time, it's very easy to plant false memories, false whatevers into people's minds. And I've talked about this in my Stephen Avery case. I'm doing a deep dive in the Stephen Avery case and Brendan Dassey. And in that regard, I talked about that, how interviewing children, you're not supposed to be doing that, that's for sure. And how false memories can be implanted very easily in times of trauma. And that is the case in which Penny Bernston, the first woman who was a victim of a brutal assault, Stephen went to prison for 18 years for that, wrongfully. And it had a lot to do with planting false memories in her mind of what the perpetrator looked like. So there's that. But anyways, I digress. All right, so the defendant did not want the relationship to end, and again refused to leave the house. So again, that's coming from the kids who had been corrupted, because they are on the McCabe side. They don't want to talk to Karen, so that's what I think happened. Anyways, officers also recovered text messages exchanged between the defendant and O'Keefe on January 28th and voicemails that the defendant left O'Keefe on January 29th after 1 a.m. So to preface this, Karen, again, this is Judge Cannone talking about this, but she doesn't know the ins and outs of this case. Like people like me, people like Turtle Boy knows this case like the back of his hand. But we know the little details, and her little details are a little skewed. So anyways, Karen and John did have some struggles in their relationship, and Karen admits to that. One of the more recent struggles was that they had been on a trip to Aruba. It was like a big friend gathering thing, and she was mad at John because he was spending more time out partying and talking to other girls while Karen was in the room taking care of the kids. So she felt used, and she felt like, yeah, she was hurt. And I'm sure maybe some jealousy, whatever. She's human. She can feel those things. That doesn't make her a life ender. So, and I also want to say, who hasn't left a voicemail or said something nasty to somebody that they really love in a time of anger? All of us have done something that we regret when we're angry. So that being said, and this was also, in reference to this night, she left John at this house. She's expecting a phone call or something for him to come for her to go pick him up, or she's expecting him to, walk in the door at any moment, and it's almost 5 a.m. and he's still not home. So she's obviously concerned. But before that, she was angry. Before she got concerned, she was angry, and that's normal because she didn't know he was not alive anymore or about to not be alive. So Leading up to the night at the waterfall, the defendant and O'Keefe exchanged several text messages about their strained relationship. In the voicemails that the defendant left O'Keefe on the 29th, she stated, quote, "You are effing using me right now. You are effing another girl. You are an effing loser. Go F yourself." And she called him an effing pervert. And she yelled at him, "John, I effing hate you." Okay. She was angry. She was also drinking. Her senses are a little, I mean, when she wouldn't be drinking, she might not say those things to him. So she was angry. I get that. Move on. That doesn't mean she hurt him. That doesn't mean she did something to him. And if she's calling him at this time at 1 a.m., which he's supposed to have been already, she is supposed to have already backed over him. Why is she calling him at 1 a.m., asking where he is, wanting to know where he is? Why is she angry at him? Wouldn't she be like leaving lovey-dovey messages? She would be doing the opposite, or not calling him at all. You know what I'm saying? She wouldn't be calling him at 1 a.m. and cursing him out. If she just ended his life, that's pretty dumb. All right, so legal standard. A defendant may be entitled to dismissal of an indictment if the integrity of the grand jury was impaired by a prosecutor's improper conduct in the introduction of certain evidence. So that they're citing Commonwealth versus Brown. The heavy burden to show impairment of the grand jury proceeding is borne by the defendant. So, okay, the defendant the defendant bears the burden of showing us that it is, sorry, Hazel, I just put my water bottle on her. So she is, telling us that it is the defendant's burden to show that there was some kind of impairment in the grand jury proceedings. The defendant must establish that 1, the Commonwealth knowingly or recklessly presented false or deceptive evidence to the grand jury. I would say, yeah, they did. Number 2, the evidence was presented for the purpose of obtaining an indictment. Yeah, I would say it was, because they didn't want their boy Colin going down for it. And number 3, the evidence probably influenced the grand jury's decision in the indictment. Yeah, I would say that they met their burden. Commonwealth versus Silva and Commonwealth versus Mayfield. All right, so in certain instances, the failure to disclose known information may impair the grand jury proceedings. Prosecutors are not required in every instance to reveal all exculpatory evidence to a grand jury. However, they must present exculpatory evidence that would generally undermine either the credibility of an important witness or evidence likely to affect the grand jury's decision, as well as evidence the withholding of which would cause the presentation to be seriously tainted. Well, yeah, if you're hiding witnesses like Lucky Laughran and people who were on that street and they said that they didn't see a body at 2 a.m., that's pretty, that's exculpatory for Karen. You're hiding stuff like that. That's, I would say, meeting this whatever criteria. So, quoting Commonwealth versus Cox. All right, so see also Arroyo, Dell. We require the prosecutors not distort the meaning of the evidence that they present by withholding certain portions of it. If the defendant can show that the prosecutor omitted such exculpatory evidence and that the evidence withheld would likely have affected the grand jury's decision to indict, dismissal is warranted. Because there is no, quote, satisfactory, comprehensive statement of what conduct does and what does not impair the integrity of the grand jury process, the court must deal with the conduct in question case by case. Discussion. As noted above, the defendant maintains that the Commonwealth knowingly and recklessly presented false and deceptive evidence to the grand jury and withheld exculpatory evidence for the purpose of obtaining the indictments. Yeah, when you hide the "How's Long to Die in Cold" Google search at 2:27 a.m., I would say that that's withholding exculpatory evidence for the purpose of obtaining an indictment. The defendant also maintains that the Commonwealth deliberately admitted inadmissible evidence to secure the indictments. The court addresses each of the defendant's several arguments for dismissal in turn. Number 1, Sergeant Lank's false and deceptive statements and the conflict of interest. Listen to this, guys. All right, so the defendant argues that Canton Police Sergeant Michael Lank, who was one of the first officers to arrive at the scene on the morning of the 29th, gave false and deceptive testimony to the grand jury, and he withheld evidence of his personal relationship with the Albert family. Specifically, the defendant contends that the Commonwealth and Sergeant Lank, 1, gave false and deceptive testimony to the grand jury regarding purported admissions made by the defendant, 2, gave deceptive testimony as to the reason the state police took over the investigation from the Canton police. Ooh. So what was his reason? And 3, withheld exculpatory information as to Sergeant Lank's long-standing relationship with members of the Albert family. So she states, the defendant's statements at the scene. With respect to the first argument, Sergeant Lank testified, so officers that were there prior to my arrival had attempted to speak with Reed, but from what I had gathered from them, she was too hysterical and was unable to really assist us in any way. The only information they were able to retrieve from her is that she could not recall whether or not she had been there. She was in shock. The defendant contends that the testimony impaired the grand jury proceedings because it was not based on personal observations, distorted the defendant's statements to the responding officers. Ooh, so what did he say that wasn't true? And strongly suggested an admission of guilt. Yeah. Anyways, so after careful review, the court concludes that this testimony does not meet the standard for dismissal. I don't know, Judge Cannone, why you and I have such different views of these things. To establish that the Commonwealth impaired the integrity of the grand jury, the defendant must first demonstrate that false or deceptive evidence was given to the grand jury knowingly or with reckless regard of the truth. Nothing before the court suggests that Sergeant Lank gave knowingly false testimony to the grand jury or that the Commonwealth sought to deceive the grand jury with the presentation of his testimony. Sergeant Lank clearly stated that his knowledge of the defendant on the morning of January 29th came from what he had gathered from other officers who spoke with Reed, not his personal observations. Indictment may be based on hearsay so long as the hearsay testimony is not used to deceive the grand jurors. But it is. They were. They were trying to deceive. Moreover, although other evidence presented to the grand jury demonstrates that the officers on the scene obtained more information from the defendant than that stated by Sergeant Lank, nothing before the court demonstrates that those other officers communicated that information to Sergeant Lank or that he purposely withheld it from the grand jury. See Mayfield, whatever. Okay. Inaccurate statements made in good faith do not require dismissal of an indictment. How do we know this was in good faith? Come on, Judge Cannone. You suck. Even if Sergeant Lank knowingly or recklessly gave a false statement to the grand jury, the defendant has not established that the Commonwealth presented Sergeant Lank's testimony for the purpose of obtaining the indictment or that it probably influenced the grand jury's decision to indict. Prior to Sergeant Lank's testimony, the 3 police officers who were first on the scene testified before the grand jury as to their first-hand observations of the defendant and statements she made. Canton police officer Stephen CvrUp described the defendant as very, very distraught, very upset. She kept loudly and hysterically saying, "This is my fault, I can't believe this happened," and asked several times if O'Keefe was going to not live. So just because she said, "This is my fault and I can't believe this happened," means I can't believe this is happening right now to us. Like, I can't believe this is going on. That has nothing to do with guilt or anything. And just because she was hysterical doesn't mean anything. But well, to me, actually, the fact that she's hysterical means that she was emotionally involved, whereas these other people on the scene were robots. There's a man in the snow that's passed out. That's Jim McCabe's voice or call to the dispatcher. So, I mean, Karen being upset actually helps support that she didn't know this was happening. She was in a state of shock, and the others already knew what was going on or weren't in shock at all. So it says something. But the fact that she said this is my fault, if she said that, that doesn't mean I hit him. That doesn't mean I ended his life. That could mean I shouldn't have left him here. I should have checked on him. I should have whatever. Like, everybody thinks it's their fault. Everybody thinks there's something that they could have done to save someone's life, especially a loved one, a very close loved one. So just because she says that isn't proof of anything. All right, so Canton police officer Stephen Mullaney described the defendant as hysterical and distraught and repeatedly screaming, "Is he dead? And that's my boyfriend." Canton police officer Sean Good described the defendant as hysterical, continually yelling, "Is he dead?" Officer Good asked the defendant how O'Keefe ended up outside the residence, and she stated, "I don't know." He asked if she drove O'Keefe there the night before, and she stated, "I think so, and then I can't remember." He stopped asking her questions because she was too upset and she was unable to keep a train of thought. Given the preceding testimony of these three officers, it is highly unlikely that the Commonwealth sought to deceive the grand jurors into thinking the only information officers could gather from the defendant was that she did not remember whether she had been to the Albert residence. What? There's more to it than that, of course, but why? I don't know what she's saying here. Sorry, I had to plug my computer in. So she's saying it is highly unlikely that the Commonwealth sought to deceive the grand jurors into thinking the only information that officers could gather from the defendant was that she did not remember whether she had been to the Albert residence. For that same reason, it is equally unlikely that Sergeant Lank's testimony made a difference. But it wasn't just about that. It was about his relationship with the people in the house, and is he even truthful in his statements? And there were no signed statements by any witnesses. It was all police reports, written, summarized in someone else's words. So you can't even trust the statements necessarily. All right, so state police involvement in the investigation. The defendant also argues that Sergeant Lank gave deceptive testimony as to the reason that the state police took over the investigation from the Canton Police Department. Specifically, the defendant contends that Sergeant Lank's testimony that the state police, quote, assumed jurisdiction and, quote, took over the investigation as soon as it was determined that O'Keefe was deceased, was an effort to conceal the fact that the Canton police lost jurisdiction in the case because the agency was conflicted. So the Canton police were recused because Kevin Albert, a Canton police officer, is related, the brother of the homeowner. So the Canton police recused themselves. However, that didn't stop them from doing the very first search of the house. But that is why. But now they're saying that Sergeant Lank told them that they took over the investigation because they assumed jurisdiction over state police assumed jurisdiction because he was deceased. That was what the state is saying. But it's not true. They lost it because of the conflict. The defendant has not shown that Sergeant Lank, that his testimony in this regard was false or deceptive, or that he withheld exculpatory evidence. His testimony as to the reason the state police took over the investigation is consistent with whatever statute that is, which requires that the Norfolk County District Attorney's Office and its law enforcement representatives, here the State Police Detective Unit, direct and control an investigation of the unaliving that occurs under the circumstances presented by the case, the district attorney or his law enforcement representative shall direct and control the investigation of the unaliving in the circumstances enumerated in Section 3, and shall coordinate the investigation with the Office of the Chief Medical Examiner and the Police Department within whose jurisdiction the unaliving occurred. The defendant has not put forth any evidence that suggests the state police took over the investigation for some other reason. The defendant refers only to Boston Globe article wherein Norfolk County District Attorney Michael Morrissey, is quoted. So the quote of the district attorney is not good enough for Judge Bev Cannone to see this. Like, it's not a good enough source. She's saying that the defendant refers only to the article wherein Michael Morrissey is quoted as saying the Canton Police Department recognized a potential conflict early on and recused itself from the case. This article is neither competent evidence that the court can rely upon for purposes of this motion, nor does it lead to the conclusion that Sergeant Link falsely testified that the state police took over the investigation once it was determined that O'Keefe was deceased. Moreover, because the state police directed and controlled the investigation and the Canton police officers testified only as to their involvement when O'Keefe's body was first discovered, it is unlikely that if the grand jurors had known the Canton police had a conflict in connection with the investigation, it would have made an impact on their decision to indict. So again, she's saying if they knew all the details, it wouldn't have changed their decisions. Come on. They were already unsure and were asking more questions about the Alberts and their relationships with the people. So relationship with the Alberts, the defendant contends that the Commonwealth intentionally withheld exculpatory information that Sergeant Link had a long-standing relationship with members of the Albert family and that he had in the past deputized him to shield the Alberts from criminal liability. I mean, those are good words. I like it. Defendant's memorandum at 19. All right, so in support of this argument, the defendant cites a complaint filed in a civil action against Sergeant Link regarding an incident that occurred in 2002 where Sergeant Link, while off duty, allegedly physically assaulted two individuals and had one arrest after they had an altercation with Tim Albert, Brian Albert's brother. The case later settled. So this is 2002, 20 years before John O'Keefe lost his life by a different Albert, Brian Albert. Yeah, so Sergeant Link, while off duty, allegedly physically assaulted two individuals and had one arrested after they had an altercation with Tim Albert, the brother of Brian, homeowner. The case later settled. According to the defendant, the Commonwealth's failure to disclose this information impaired the integrity of the grand jury proceedings because, had the grand jurors known of this incident, it would have undermined Sergeant Link's credibility in this case. I agree, it would have. This court... I apologize. My dogs heard something outside and they got real crazy. And I couldn't stop it before I got on the mic. Sorry about that. All right. So according to the defendant, the Commonwealth's failure to disclose this information impaired the integrity of the grand jury proceedings because, had the grand jurors known of this incident, it would have undermined Sergeant Link's credibility in the case. The court is not persuaded. The Commonwealth's obligation is to present exculpatory evidence that would greatly undermine either the credibility of an important witness or evidence likely to affect the grand jury's decision, as well as evidence the withholding of which would cause the presentation to be seriously tainted, like the how's long to die in cold. Yeah, that would be seriously tainted if you forgot to tell the grand jurors about that. The The defendant has not directed this court to any case law that suggests allegations in a civil complaint from 20 years ago against one of the many police officers preliminarily involved in the investigation would be considered exculpatory evidence. Allegations from a civil lawsuit which was not fully adjudicated are not exculpatory evidence. Informing the grand jury that the police informant had convictions for larceny and breaking and entering. This is according to this Commonwealth versus whatever, which one. So informing the grand jury that the police informant had convictions for larceny and breaking and entering 6 years before the investigation into the defendant began would not have undermined the credibility of the evidence. Well, I think it does. Nor is there any evidence before the court that Sergeant Lank engaged in conduct during his brief involvement with this case that suggests he was not impartial. And footnote says, to the extent that the defendant contends that the Alberts did not come out of their residence at the time O'Keefe's body was discovered because they were waiting for their friend Sergeant Lank to interview them, that assertion is purely conjecture. The testimony before the grand jury was that Brian Albert and his wife Nicole were sleeping during the early morning hours when the body was discovered. Yeah, and they were melting snow with the snowblower for 2 hours. So how did you not wake up to that or see any or hear any of the fire trucks or ambulances or anything that was on scene? How did they not see that? Cop cars should have been there. Your buddies would have been on scene. I'm sure they would have been calling you. All right, so, yeah, right, he's impartial. Even if knowing that Sergeant Lank had a history of friendship with Brian Albert's brother may have colored the grand juror's view of the testimony, Sergeant Lank was one of many police officers who testified before the grand jury, and his role in the investigation was minimal. But, okay, no, not really. It wasn't that minimal because he took statements of the quote-unquote witnesses. So it wasn't minimal. He should have been interviewing them like they were suspects, but no, he interviewed them like witnesses. Given the extensive amount of other evidence... Oh, wait, I skipped something. Sorry, hold on. His entire testimony makes up only 27 pages of the grand jury transcript, which is over 1,400 pages in length. So, that doesn't mean that he's minimal. That's still 27 pages of grand jury testimony. So, given the extensive amount of other evidence against the defendant, it is unlikely that disclosure of the withheld information would have affected the grand jury's decision to indict. I don't know. Trooper Michael Proctor's false and deceptive statements and conflict of interest. What does Cannone have to say about that? So the defendant argues that the state police trooper, Michael Proctor, the homicide investigator for the Norfolk County District Attorney's Office, who co-led the investigation into O'Keefe's unaliving, gave false and deceptive testimony to the grand jury and failed to disclose that he had a personal relationship with other percipient witnesses. Yeah, he did. He did fail to disclose that. And he only disclosed it recently in front of another grand jury. Specifically, the defendant contends that the Commonwealth and Trooper Proctor, 1, withheld from the grand jury that Trooper Proctor is a close family friend of the Alberts. Yes, he withheld that. That is true. 2, that he failed to inform the grand jury that there was an alternate explanation for the defendant's broken tail light. Yeah, he failed to mention that, for sure. And 3, withheld from the grand jury that the death certificate stated that the manner of his unaliving could not be determined. Not that he was hit by an SUV. She did not say that, the medical examiner. All right, so relationships with the Alberts. With respect to the first argument, the defendant has proffered evidence that shows Trooper Proctor's sister was friends with Jennifer McCabe and Julie and Chris Albert, the brother and sister-in-law of Brian Albert. Oh, geez, that's a lot of footnotes. So to the extent that the defendant argues Trooper Proctor's relationship with these and other witnesses is closer than what is shown in the evidence before the court, such an issue is properly dealt with at trial on cross-examination. So don't bring it to me before at these pre-trial hearings, because you can deal with it in cross-examination. Even assuming that Trooper Proctor had a personal relationship with these witnesses, disclosure to the grand jury was not necessarily required. Only when the prosecutor possesses evidence which would greatly undermine the credibility of evidence likely to affect the grand jury's decision to indict must he alert the grand jury to the evidence of such, or to the existence of such evidence. I would think that it would be a big deal to the grand jury knowing that the lead investigator was not just friends, but good friends, family member relationship type friends with the Alberts, the homeowners. I bet that would change their minds a little bit. The defendant has not pointed to any case law that suggests a police officer's credibility is greatly undermined if he knows witnesses in this case. It is like Investigation 101. They teach you that on day one. Don't know the people that you're investigating. I mean, I think it should have gone without saying. 5. The court notes that there is an ongoing federal inquiry into the investigation of O'Keefe's unaliving, and the state police is also currently investigating Trooper Proctor. The Commonwealth and the defendant have received numerous documents regarding the federal investigation pursuant to a TUI request, and the defendant cites several documents as evidence of a long-standing compromising relationship between Trooper Proctor and the Alberts. The court has reviewed all the documents from the federal investigation. The federal investigation, while they reveal several examples of Trooper Proctor's unprofessional and questionable conduct, they do not shed much light on the extent of the relationship with the witnesses and what impact, if any, the relationships had on this investigation. Really? So it's okay that Sergeant Lank knew them and was close friends with them. It's okay that the Canton police were investigating even though they should have not been doing anything there. It's okay that Trooper Proctor is family member type friend with the Alberts and the McCabe's. Is that okay? I mean, according to Judge Bev, it is. At this time, no specific evidence cited by the defendant's warrants dismissal. Okay, get out of here, Judge Bev. All right, so even if Trooper Proctor's familiarity with the witnesses suggests some sort of bias in the investigation that the grand jury may have considered to warrant dismissal, the defendant must show that the absence of the withheld evidence likely would have affected the grand jury's decision to indict. I mean, what do you guys think? I think they gave plenty of reasons why this should have been dismissed. The grand jury heard extensive evidence supporting probable cause to believe that the defendant struck O'Keefe with her vehicle. Therefore, even if the grand jury had been aware of Trooper Proctor's relationship with the Alberts, it would almost certainly have left unaltered the disposition to indict. Okay, so they still would have wanted to indict, but okay. But the sufficient evidence... The grand jury heard extensive evidence supporting probable cause. That probable cause is taillight, right? I mean, and the whole I hit him that could have been coming from Jen McCabe and Carrie Roberts. They could have made her think that she hit him. So that's their evidence, but yet... And then Trooper Proctor, the tail light that is supposed to corroborate this whole story that she hit him is planted there multiple times. Trooper Proctor, the best friend of the Alberts, is towing the truck and taking it to Canton PD. That's right. They dropped it off at Trooper Proctor or State Police. They dropped it off at Canton to leave it there in their bay. I don't know why it was brought to Canton PD, but it was, even though Canton had already been recused at that point. There are a lot of fishy and inconsistent things within the investigation, and Judge Cannone is like totally ignoring all that. And if you watched the hearing that she had, that they had yesterday, Cannone was so mean. Like, she was so grumpy towards the defense. She hates Alan Jackson. Like, she was horrible to him on Zoom, even though she told him he could be on Zoom. In the prior hearing, she didn't want him to talk because he was on Zoom on this one. So she's just all over the place, and she is so biased. It is so unbelievable, and you can see it coming through in this motion or memorandum and in the way that she treats the defense versus Lolly, who hasn't fulfilled his responsibility yet of completing all of his discovery requirements to the defense. He hasn't done that yet. Trial's 3 weeks away, and she laughs it off, and she's like, okay, well, so the defense, can you get your reciprocal discovery over to them like in a day? She doesn't even care that Lolly hasn't completed his discovery requests. It's ridiculous the way that she's kissing Lolly's butt and acting horrible to Karen. I don't like it. Anyways, all right, where did I leave off? So it would be unaltered. Okay, so alternate explanation for the broken taillight. Turning to, oh wait, I missed this big long thing here. So citing Sergeant Buchanan's testimony, the defendant also argues that the Commonwealth intentionally misled the grand jury as to Trooper Proctor's relationship with Chris and Julie Albert. Sergeant Buchanan read to the grand jury his report of the interview that he conducted with Trooper Proctor of Chris and Julie Albert. The report began with the words, "Following formal introductions." The court does not agree that this testimony was intentionally misleading. Bullshit. Bullshit. They specifically put in their paperwork, in their report, that following formal introductions, we sat down and asked them questions. You don't formally introduce yourself to somebody you already know for several years, which is the case. They do know each other. So I don't know. I mean, not just know each other, they know each other very well. They're BFFs. All right, so the court does not agree that that's intentionally misleading. Whatever. Sergeant Buchanan wrote the report, and there is no suggestion that he knew either of the witnesses or used this language to misrepresent Trooper Proctor's connection to Chris and Julie Albert. Okay. All right, so alternate explanation for the broken taillight. Turning to the second argument, Trooper Proctor testified that the state police viewed footage from Ring cameras at O'Keefe's residence, including one camera located above the garage doors. The Commonwealth showed the grand jury the video, and Trooper Proctor testified as to what he saw. He stated that at 5:07 a.m. on January 29th, the defendant is seen reversing out of the garage and driving off. As she backed out of the garage, her right rear tail light came extremely close to Mr. O'Keefe's SUV. Extremely close. Just close. But we can tell that John's SUV moves in the snow. We can see his tire lunge forward. We can see the car do a jerk. We can see it on video. So to say that it's extremely close is misleading. Yes, that's false. No pieces of taillight were viewed anywhere in the driveway that day, and no damage was observed anywhere. And that is because the, oh, that was still part of that. Darn it. So no pieces of taillight were viewed anywhere in the driveway. That's because her taillight cracked. It was initially cracked. Everyone said that. Karen, Carrie Roberts, and Jen McCabe all said it was cracked. Then later in the night it becomes shattered, and then later it becomes shattered with missing pieces. They kept adding to it and adding to it because Trooper Proctor had every intention to go in there and shatter the rest of that taillight, because once they saw, oh, she got a cracked taillight, we're going to go in and use that as our evidence to plant against her. And that's exactly what they did. The defendant argues that this testimony was misleading because her vehicle did strike the SUV, breaking her taillight. It did. Yes, it did. Thus providing an alternative explanation to the Commonwealth's theory that the taillight broke when the vehicle struck O'Keefe. Nothing about Trooper Proctor's testimony was misleading, according to you, Judge Cannone, but it's absolutely misleading. The Commonwealth was not obligated to offer an alternate explanation for the broken taillight. No, they weren't obligated to offer an alternate explanation. They were obligated to tell the truth, but they didn't, and they lied about the taillight. The Commonwealth was not obligated, to tell them about the broken taillight. The Commonwealth is not required to present evidence of so-called defenses or otherwise disprove such matters before the grand jury. And that I totally get. They don't have to provide other alternative theories, but they do have to provide truth and truthful testimony and truthful evidence that is done and collected in the proper way, which they did not do. Nor does the fact that the defendant has a different interpretation of the video make Trooper Proctor's testimony false or misleading. Moreover, the ring video was introduced into evidence before the grand jury, allowing the grand jurors to assess whether the defendant's vehicle made contact with O'Keefe's SUV. Accordingly, there is no merit to the defendant's argument that Trooper Proctor's testimony about the ring video impaired the integrity of the grand jury. Well, I think it would help them to know that maybe her taillight got broken there and not at 12, but more at 5 a.m. You know, they might want to know that, especially when there's missing library footage, surveillance footage from the library where she would have driven past and her taillight would have been displayed on the video. It's missing the exact 2 minutes when she would be driving by. All right, so O'Keefe's certificate of his unaliving. The defendant lastly contends that the Commonwealth attempted to deceive the grand jury with its presentation of evidence regarding O'Keefe's certificate. During the proceedings, Trooper Proctor testified that the cause of his unaliving listed on the certificate was blunt impact injuries of head and hypothermia. He was not asked and therefore did not testify that the certificate listed the manner of death as could not be determined. According to the defendant, like Odell, the Commonwealth distorted the evidence by only presenting a portion of the information from the certificate. This argument, too, is unavailing. So Cannone's like, yeah, it's unimpressive. I don't care. The circumstances here are markedly different than Odell. In Odell, the police detective read the grand jury an edited version of the defendant's statement to police in the aftermath of an armed robbery. As edited, the statement suggested an admission of guilt by silence when, in fact, the defendant had disclaimed any knowledge of the robbery to police. The Supreme Judicial Court held that the omission of part of the defendant's statement was not a mere withholding of exculpatory evidence, but tended to distort the meaning of that portion of the defendant's statement that was repeated to the grand jury. Here, unlike Odell, omitting that the manner of death could not be determined did not tend to distort the meaning of his cause of unaliving. Indeed, this information sheds no light on the cause of his unaliving. The manner of death? Yeah, I think the way in which he died does matter. I do think it matters. Indeed, this information sheds no light on the case of his unaliving. So says Judge Cannone, where the evidence presented to the grand jury was not distorted by the omission did not impair the integrity of the grand jury, nor does it inculpate or exculpate the defendant. Moreover, because this certificate was submitted to the grand jury as an exhibit, the medical examiner's conclusion as to the manner of his unaliving was not concealed by the Commonwealth. Accordingly, Trooper Proctor's testimony as to the certificate did not distort the presentation of the evidence. I don't agree with her there. So a footnote says, the court notes that it is more likely that the Commonwealth did not elicit testimony about the manner of his unaliving because generally it is impermissible as evidence. Nothing contained in the record of his unaliving, which has reference to the question of liability for causing his unaliving, shall be admissible in evidence. The better and safer course is to exclude from a death certificate the words homicide, self-unaliving, or an accident in a criminal trial. So they don't want to tell you the manner, which those are the manners. The homicide, self-unaliving, accident, or could not be determined, it appears. Those are the manners of unaliving. And they're saying it's prejudicial or something, so you can't use it in court. All right, so before the grand jury, Chris and Julie Albert testified that they were at the waterfall the night of January 28th, but that neither went back to the Albert residence afterwards. Julie went home early with a headache. Chris walked home when everybody left the bar. Why would he walk home? Oh, because she left early. She did leave the bar early before it all closed. So Chris walked home from the bar. Nobody could give him a ride? That seems odd to me. All right, so Sergeant Buchanan, it's January. It's cold out. It was snowing. And he walked home? This is the first time I'm hearing this. You guys? Is this the first time you're hearing about Chris Albert walking home from the bar? This is the first time. I'm surprised. Okay. So Sergeant Buchanan testified as to his interview with Chris and Julie Albert on February 10th, where both made similar statements. The defendant contends that Sergeant Buchanan's February 21st report memorializing his interview of the witnesses indicated that Julie and Chris Albert did go back to the Albert residence after the waterfall and that the Commonwealth intentionally failed to elicit Chris Albert's inconsistent statements before the grand jury. Okay. The defendant refers to the report Exhibit G to her motion. However, the defendant has only submitted to the court's Exhibits A through F. Whatever. Okay. So given that Chris Albert testified consistently with Sergeant Buchanan's February 10th report that was read to the grand jury, it does not appear to the court that he did, in fact, give an inconsistent statement. The error appears to lie in Sergeant Buchanan's later report. Eliciting the inconsistency in Sergeant Buchanan's report would not likely have affected the grand jury's decision to indict. Accordingly, dismissal is not warranted based on this argument. Nor is dismissal warranted based on the defendant's argument that the Commonwealth failed to impeach Julie Albert with her prior inconsistent statement regarding how she found out about John O'Keefe's unaliving. Julie Albert testified before the grand jury that on the morning of January 29th, she woke up at 5:50 a.m. and saw that she had a missed call from Jennifer McCabe. She didn't think, obviously, anything bad, got out of bed, changed her clothes, and headed over to the Albert residence to drop off a gift for her nephew's birthday, which was Brian Albert Jr.'s birthday the night before, which is why they were all out celebrating. Upon arriving at the Albert residence, she learned of O'Keefe's unaliving. Sergeant Buchanan read his report memorializing his interview with Julie Albert on February 10th, in which she gave a different account of the morning. She told Sergeant Buchanan that she was asleep at 4:55 a.m. on January 29th when her phone woke her up, and there was Jen's missed call, and that is how she found out about O'Keefe's unaliving. The court does not agree with the defendant. The court doesn't agree with anything the defendant says, apparently. That the Commonwealth's failure to impeach Julie Alberts warrants dismissal. First, the Commonwealth did not withhold Julie Alberts' inconsistent testimony from the grand jury. Contrast in Odell, both her testimony and the statement that she gave Sergeant Buchanan were before the grand jury. It is therefore not the case that the Commonwealth carefully scripted the testimony in order to hide the ball on the grand jury regarding Julie Alberts' inconsistent statements. See Commonwealth versus Hunt. Prosecutor presented witnesses' identification of defendant but omitted witnesses' prior statement that she could not identify the perpetrators. All right, whatever. That's this other case. All right, so moreover, even assuming Julie Albert falsely recounted how she found out about O'Keefe's unaliving during her grand jury testimony, the defendant must show not only that the evidence was material to the question of probable cause, but on the entire grand jury record, the false or deceptive testimony probably would have affected the decision to indict. The court does not agree with the defendant's assertion that the difference in testimony clearly inculpates Julie Albert and exculpates Ms. Reed, defendant's memorandum at 26. It is more than an inferential leap to conclude, as the defendant does, that Julie Albert's statement to Sergeant Buchanan suggests that she and Julie McCabe knew O'Keefe was unalive before his body was discovered that morning. How? I don't know. Okay. Highlighting the discrepancy in Julie Albert's testimony would not likely have undermined the value of other evidence tending to show that the defendant committed the crime. That's not true, though, because it would, all of these witnesses are not credible, so you're breaking them down one by one, and you're taking them out for other reasons, but when you look at it down to its simplicity, all of these people are unreliable and not credible. All of them. Alberts and McCabe's, your witnesses in the case. So it is more than an inferential leap. Okay, I read that, sorry. Highlighting this discrepancy would not likely have undermined the value of other evidence tending to show that the defendant committed the crime. It's crazy. Introduction of propensity and bad character evidence. The defendant argues that the Commonwealth improperly presented the grand jury with prejudicial propensity and bad character evidence for the purposes of obtaining the indictment. Specifically, the defendant objects to 1. The defendant's presentation of evidence from a trip to Aruba that occurred a month before O'Keefe's unaliving, where the defendant accused O'Keefe of having an affair. And yeah, like, that doesn't have anything to do with anything. I mean, if she was angry at him and he was being flirty with another girl in Aruba, yeah, I'd be PO'd too. You know, I'd be mad. All right, and number 2, that the Commonwealth's presentation of hearsay evidence regarding the state of the defendant of O'Keefe's relationship and the defendant and O'Keefe's relationship. The court concludes that the presentation of this evidence did not impair the grand jury proceedings. Of course you conclude that. There is no evidence before the court that the Commonwealth presented any false testimony with respect to the events that transpired in Aruba or the defendant and O'Keefe's relationship leading up to January 29th, nor does the court find such evidence to be improper propensity evidence. Prior bad act evidence may be relevant in a grand jury presentation to show something other than propensity. No error in presentation of certain evidence to grand jury where evidence was relevant to show intent and motive. All right. In particular, prior bad act evidence is relevant to show a hostile relationship between a defendant and a victim and to show state of mind and motive. See Commonwealth versus Bianchi. The evidence presented here was relevant to the defendant's state of mind on the night of the incident and her motive to commit the crime. Additionally, where other evidence before the grand jury demonstrated the strained and hostile nature of the defendant and O'Keefe's relationship leading up to January 29th, it is unlikely that the events in Aruba were presented for the purpose of obtaining an indictment. Well, why else would you present it? footnote here says the court acknowledges that the Commonwealth's presentation of prior bad act testimony with respect to the Aruba trip may have been excessive, and as a result, some of the evidence may have been more prejudicial than probative. So it was excessive. You admit that. You admit it. However, looking at the evidence in its totality and keeping in mind the Commonwealth's relatively low burden of proof to obtain an indictment and the defendant's heavy burden to show impairment of the grand jury proceeding, it is not evident that absent the prior bad act evidence, the jury likely would have decided to indict. I think it goes to motive, though. You're throwing a motive in there that doesn't necessarily exist. I mean, and a motive for a crime that she didn't even do. So there's that. But I don't know. I have a hard time with that. All right, so where the grand jury were presented with sufficient probable cause to issue the indictments, the prior bad act evidence did not sufficiently influence the grand jury's decision to indict, to require dismissal of the indictments. There was little chance that the grand jury could have been led to indict defendant on the basis of an apparent propensity to commit such crimes rather than on the direct and overwhelming evidence. But there is no direct and overwhelming evidence that she hit him with her car. Just want to say that again. There is no evidence that she hit him with a car. All of his wounds show that someone beat him up. Someone and a dog beat him up. The presentation of hearsay evidence regarding the defendant's relationship with O'Keefe was also not improper. It is well established that an indictment may be based in whole or in part on hearsay. The defendant has not directed this court to any instance where hearsay testimony was used to deceive the grand jury, noting that if a prosecutor were to deceive grand jurors by presenting remote hearsay in the guise of direct testimony, it may result or impair the integrity of the proceedings. Accordingly, the presentation of hearsay testimony does not warrant dismissal. Introduction of lay witness and expert opinion. The defendant contends that the Commonwealth introduced incriminating lay and expert opinion testimony and rank speculation for the purpose of obtaining the indictment. The defendant cites 3 specific examples which she contends impaired the grand jury process. State Police Officer David DeSico. First, the defendant contends that the Commonwealth elicited improper hearsay testimony from State Police Officer David DeSico. Officer DeSico testified that O'Keefe's brother stated that he went to the hospital to view O'Keefe's body and it looked like he had been hit by a car. According to the defendant, such testimony improperly served as expert testimony and was intended to substitute for the absence of testimony as to the manner of his unaliving. I agree. You have a cop up there saying something about the way that he looks like he had been ended, and that is, you take that person as expert, even if he's not qualified as an expert. People in the jury box don't understand what a qualified expert means legally speaking, so you still think he might be in the capacity of an expert in that, even if he's not. So you're going to believe his testimony. Anyway, so according to the defendant, such testimony improperly served as expert testimony and was intended to substitute for the absence of testimony as to the manner of his unaliving. This argument is wholly without merit. Nothing about the testimony would lead the grand jury to believe that the statement was an opinion based on scientific, technical, or some other specialized knowledge. Thus, the testimony was neither false nor deceptive, even if such a statement would be inadmissible at trial, given the context of the statement and its relative unimportance in comparison to the other evidence. What other evidence do they have besides planted taillight? It is also highly unlikely that it was elicited for the purpose of obtaining an indictment or that it probably influenced the grand jury's proceedings or decisions. Testimony from the McCabe's. Second, the defendant argues that the Commonwealth elicited speculative testimony from Jennifer McCabe and her husband, Matthew McCabe. With respect to Matthew, the defendant contends that the Commonwealth asked him to speculate as to the reason the defendant's car was parked outside the Albert residence for a period of time, but neither O'Keefe nor the defendant entered the residence. The grand jury heard testimony from Jennifer McCabe that after arriving at the Albert residence from the waterfall, she was looking out the window. Her and Matt, her husband, just spend time at parties looking out windows at the front door, wide open in the middle of winter. She was looking out the window when she saw the defendant's vehicle pull up to the front of the house. Over the next 15 minutes, 15 minutes is not accurate either. She was there 5-10 minutes max, because she was back at home calling John, and she was definitely not there 15 minutes. So Jen McCabe noticed that at some point the vehicle moved to a different spot. During that time, Jennifer McCabe texted O'Keefe and accidentally called him, but he did not answer. She further testified that at some point the vehicle was no longer there, and she assumed that the defendant and O'Keefe had left and gone home. So that is her testimony as to the 15 full minutes that the car was sitting out there, which is not true. It was less than 10. However, the question posed by the prosecutor about how long the defendant's car was in front of the house, not the reason it was there. So a fairly significant amount of time, is that correct? Thus, contrary to the defendant's contention that the Commonwealth did not elicit speculative testimony from Matt McCabe to fill a gaping hole in the Commonwealth's case. Moreover, Matthew's response made it clear that he had no idea as to why the vehicle was parked out front for so long. He says, yes, the car was out there. We just thought it was weird, you know. In hindsight, were they having a disagreement in the car? I don't know. You know, I don't know why the car was out there, why it was parked there. It wasn't as if they pulled up, and I looked outside, and the next thing you know, they were gone. They definitely moved the car and for some reason never came in the house. But we know Brian Higgins has testified, Nagel. I might have said Higgins earlier. Ryan Nagel. So many people in this case, I can't get them all straight. It's Ryan Nagel who came to pick up his sister Julie Nagel, and he is the one that saw them saw Karen in her SUV sitting there alone with no one else. John was not in the vehicle, he was not standing outside of the vehicle, and he was not on the ground in front or behind the vehicle at any point in time when Ryan Nagel was there. Therefore, even if the question invited speculative testimony, given the other evidence before the grand jury that the defendant and O'Keefe had a strained relationship and were arguing that night, Matthew's testimony that he did not know if they were having a disagreement would not have made a difference. With respect to Jennifer McCabe, the defendant contends that the Commonwealth elicited speculative testimony as to why O'Keefe's niece described the defendant as acting, quote, crazy on the morning of January 29th. Jennifer McCabe testified that on the morning of the 29th, when she and the defendant went back to O'Keefe's residence before going out to look for him, she talked to O'Keefe's niece, who said the defendant was acting crazy. End quote. Remember, this is a kid too, so it could just be how they were talking, you know, just acting, she could mean like she was frantic. She just doesn't know the word to describe. She was frantic. She was hysterical. She was upset. She was visibly, emotionally distraught. She doesn't know how to verbalize those words, so she said she's acting crazy. You know what I'm saying? So and she's a kid, so you can't really take it for what it's worth. And it's a figure of speech. I say it all the time. I say this case is crazy. This case is crazy, the way that everything has been unfolding. All right, so however, this testimony was prompted by a question from a grand juror, not the prosecutor. Grand juror asks O'Keefe's, so the grand juror asked O'Keefe's niece, when you spoke to her, said the defendant was acting crazy. Did you know how long you know, or any information from your conversation with the niece, like how long the defendant was there speaking to her, and what she means by quite crazy? Can you go lay down in the spot that's for you, because I'm streaming now, dog. You guys want to see the sad face that I get when I don't do what she wants? She's all sad because she wants a blanket. Come over here. All right. You need to walk around. You know how to do this. You can go over here. I'm busy. I gotta finish this. Come on. Get down and go around. Lazy. Okay. Sorry, I don't mean to distract you guys with my dog. She's just being a butthead, and she always wants to be part of the stream. So, also, someone commented on my page, like, I need to cut out all my water breaks. Like, seriously, I'm not allowed to take a water sip? Get out of here. That's unreal. I can sip my water when I need to. I'm reading, and it makes my throat dry. So I will drink water when I need to, and I'm not going to cut it out of my videos. So stop telling me to, whoever that was. I don't know. People are so rude. I just want to say that. Like, little side note, people on social media are just mean. Like, let's keep this positive. Let's keep our space positive. The comments that we say here positive. We could talk about the people in the case and, you know, call them names, whatever. But let's try to be nice. And, you know, I don't want to call people names. Let's try to avoid calling people names. But if you're going to talk about someone badly, talk about the people in this case who you don't like, the people whose side you're not on, and let me know what you think that way. Don't sit there and ridicule me and the way that I manage my channel and the way that I do freestyle videos without editing things out. So I just want to say that, because it's really been irking me, and it's almost to the point where I don't even want to do this anymore, because I can't stand the jerks that are on social media. So I just want to be clear. I'm going to do my channel my way. If you guys have a suggestion, great. Email me, let me know. But you know what? It doesn't need to be a comment telling me everything that you hate about my stream or about me, because that's not what this is about. I want to keep it positive. Positive, positive. Let's keep our comments positive. Let's uplift people. Tell me what you like about my stream. Tell others what you like about them. Do a nice thing for somebody today. Be nice. Just cut out the crap, cut out the bullshit, and be nice. There's too much hate in this world, so let's just be nice to one another. All right. Now that I got that out of the way, I don't even know where I was. All right, so thus, even if the response was speculative, it was not elicited by the Commonwealth for the purpose of obtaining the indictment. Evidence submitted in response to a question by a grand juror is less problematic than evidence submitted by the prosecutor's design. Commonwealth versus Matthews, where testimony was not offered gratuitously by the police officer or the prosecutor, but made in response to a question from a grand juror. The context suggested it was not presented to the grand jury in bad faith. So because it was a juror, not a prosecutor, it was not bad faith, I guess. The court's notes that after the grand juror posed the question, the prosecutor said to McCabe, "If you know." This interjection does not change the court's analysis, as the question originated from the grand juror, and it appears to the court that the prosecutor was attempting to minimize the possibility of speculation in the answer. So the prosecutor said, "If you know." Gotcha. Okay. So we're done there. All right. Next point. The state's police computer forensic expert Trooper Guarino's reports. So finally, the defendant contends that the Commonwealth put improper expert opinion before the grand jury, and they did. They absolutely did, Judge Cannone. When Trooper Proctor read reports from the state police computer forensics expert, Trooper Guarino to the grand jury. Pursuant to search warrants, Trooper Guarino seized an infotainment system and a telematics system from the defendant's vehicle. Trooper Proctor read Guarino's report to the grand jury. And here it goes. On Saturday, January 29th, Trooper Michael Proctor and Sergeant Yuri Buchanan of the Norfolk District Attorney's Office responded to the unattended unaliving of John O'Keefe, date of birth 75. All right. On 34 Fairview Road in Canton. Through my investigation, it was found that O'Keefe was a victim of motor vehicle homicide. Sergeant Buchanan and myself, but how? You didn't really say how you got to that. Sergeant Buchanan and myself responded to 345. Oh, Dighton. Sorry, that's the parents' residence, and secured Massachusetts, whatever, Lexus, and so they secured the SUV belonging to Karen Reed, who is a suspect in the case. The vehicle was towed to Canton Police Department as evidence. Again, Canton was recused, so why was it taken to Canton? There should be some reason why it was taken there, like a good reason, because they shouldn't have it. On Wednesday, February 2nd, the vehicle was towed from Canton Police Department to the Milton Barracks. I supplied search warrant number whatever issued out of Stoughton District Court. The evidence was secured as follows: one infotainment system, one telematics system. At that time, we were unable to access the data and analyze it. Both systems are secured at the Norfolk DA's office for future analysis. All right, so it was just weird. All right, sorry. State police also seized the defendant's cell phone and performed a cell phone extraction and forensic analysis. Trooper Proctor read Trooper Guarino's report concerning the defendant's cell phone to the grand jury. It also stated that through his investigation, it was found that O'Keefe was a victim of a motor vehicle homicide, and concluded at this time we are unable to access the data on the phone. But how do you know he was a victim of motor vehicle homicide? There is no proof at this time yet. Where's this coming from? Where is Guarino even getting that from? The defendant argues that through this testimony, the Commonwealth elicited improper expert opinion that Mr. O'Keefe was the victim of vehicular homicide, falsely insinuating to the grand jury that he must have reviewed electronic evidence in the case suggesting O'Keefe was struck by a vehicle. But there is no evidence that that happened. There is no video of that happening. They lied to us in the very beginning of this case and said that there was, but there isn't. Or there was, and they deleted it because there was video, and the video proves Karen's innocence, and that's why it's gone, because there were Ring cameras, and they had a Google Nest or whatever, and that one's called the Google something, that the Google doorbell thing. So this court does not agree with the defendant's characterization of the testimony, although it may have been misleading. She admits it's misleading. Although it may have been misleading for the report to state through Trooper Guarino's investigation it was found that O'Keefe was a victim of motor vehicle homicide, the report thereafter clearly states that the police were unable to access the data from the defendant's vehicle or phone. Therefore, it is unlikely that the testimony deceived grand jurors into believing that Trooper Guarino reviewed electronic evidence in this case suggesting O'Keefe was struck by a vehicle. Even if, as suggested by the defendant, the opening sentence of the report may have led the grand jury to believe that the police had conclusively determined that O'Keefe his life was ended by a car, given all the evidence before the grand jury suggesting that the defendant's vehicle struck O'Keefe, this testimony probably did not influence the grand jury. How can you say that when an expert on the stand says that she hit him? He doesn't say how he knows that. He doesn't say what he has to back that up. He just says that he does, that he knew that. And the jury's going to take that as expert opinion and that he has some reason to back that up. I absolutely believe that this influenced the grand jury's decision. the time of Jennifer McCabe's Google search. In her supplemental memorandum, the defendant argues that the Commonwealth intentionally and recklessly deceived the grand jury by presenting an incomplete extraction of Jennifer McCabe's cell phone as an exhibit before the grand jury. According to the defendant, the grand jury exhibit number 49 purposely left off a Google search Jennifer McCabe made at 2:27 before O'Keefe's body was discovered, stating how long to die in cold. The defendant has not shown that the Commonwealth improperly withheld this evidence. They didn't present it. They knew it. They should have known it. But they're saying they're trying to blame or fake that they didn't know it and they had the wrong version of Celebrate. Give me a break. Come on. The grand jury exhibit referred to by the defendant is a Celebrate cell phone extraction report from Jennifer McCabe's cell phone containing the call logs, contacts, instant messages, and tags in her cell phone. A more recent Celebrate report obtained during the federal investigation provides the web history of the phone, including the aforementioned Google search at 2:27 a.m. and a search for 2 other times but she spelled it wrong. This is how she spelled it. At 6:23 and then another one at 6:24, which she made sure was spelled incorrectly how she spelled it the first time, which was the house long here. So there is no evidence. Oh, hold on. Got a footnote. The court notes that the time or times of the Google search is a hotly disputed issue. Not really, though, because federal investigators have confirmed that it happened at 2:27 a.m. long before Karen was out searching for John. So there. There is no evidence that the more recent report was available to the Commonwealth at the time of the grand jury proceedings. Indeed, based on an examination of the 2 reports, it appears that the more recent report used an updated version of software which included web history, data files, and activity sensor data that the previous software did not extract. Because the Commonwealth could not have withheld information it did not have and was not aware existed at the time of the grand jury, the defendant has not established that the Commonwealth withheld exculpatory evidence from the grand jury. I find it very, 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 very hard to believe that they didn't have that search already and that they couldn't get it with the other software. I would really like it to know if someone with the prior Celebrate software did it, if they would be able to, get it. Like if the defense was able to get their hands on Jen McCabe's phone, which they are supposed to be. I wonder if you did a Celebrate extraction in the old version, if it would have that in the log. I think if anybody's watching, if anybody on the defense team can do that, I think that would be very interesting to try to prove more corruption on the Commonwealth, but you probably have enough, so you got enough corruption over there, enough proof of corruption, I should say. All right, so because the Commonwealth could not have withheld information it didn't have, it's not whatever. She doesn't think that it affected the grand jury's indictment. Collusion between Jennifer McCabe and Carrie Roberts. Finally, the defendant contends that the Commonwealth withheld from the grand jury that prior to their grand jury testimony, Jennifer McCabe and Carrie Roberts wrote a timeline of events that occurred on January 29th, and they showed that timeline to the state prosecutor. Interesting. Did not know that. Maybe that's why they want all the notes now from the prosecutor, from Adam Lally, because that's what they were arguing in court yesterday, that there are notes that the prosecution took when he met with certain witnesses, and they want those witness statements. They said redact anything that has to do with work product, anything that has to do with their trial strategy, all that. We don't need to see that, but give us the statements because that is discoverable and we need to know it. And this just proves that there is some kind of timeline that, notes that the prosecutor should have in his hands. And that timeline should be part of that. part of those notes. Anyway, so according to the defendant, by not eliciting testimony from these witnesses regarding the timeline, the Commonwealth improperly misled the grand jury into believing that Jennifer McCabe and Carrie Roberts testified to their own independent recollection of events that occurred on the 29th, because they prepped. They prepped together, and they prepped with the prosecutor, which I don't think they're supposed to do. They're not supposed to talk about what answers they're supposed to give. They're not supposed to talk about that. They're not supposed to talk about the substance of what they say. Only, well, this is what's going to happen. The prosecutor's supposed to prepare them for, this is what's going to happen. We may ask you questions about, in general terms, about the night in question. We'll ask you things about the 29th, January 29th. And then that's it. You know, like they'll tell you just little bits here and there, and they're not going to get into like all the details when they're prepping you. They shouldn't. They shouldn't give you testimony or things to say, like a timeline. The court does not agree with the defendant that the failure to elicit such testimony undermines the witness's credibility. Well, what do you know? She disagrees. And impaired the integrity of the proceedings. The two witnesses who are friends and who were with the defendant on the morning in question discussed the timeline of events that occurred before their testimony before the grand jury does not seriously undermine their credibility. How does that not undermine their credibility if they're getting their story straight with one another? Even if it may have been a better practice for the prosecutor to elicit testimony about their written timeline, the failure to do so did not seriously taint the grand jury proceedings. So she's saying right there, it would have been better practice for the prosecutor to elicit their testimony rather than a written timeline. So she's saying there that he didn't follow the best protocol there. So, yeah, but she disagrees. It doesn't have anything to do with bias towards the defendant. And this is the conclusion and order. For the foregoing reasons, the court concludes that the Commonwealth's presentation of the evidence before the grand jury did not impair the integrity of the proceedings, and the defendant's motion to dismiss is therefore denied. So there you have it. We are going to trial. I am going to let me know in the comments below if you want me to live stream the trial or do recaps of the trial afterwards. I'm definitely going to be watching the trial, so I could stream it live if you guys are interested. I would not do a whole lot of talking over everyone because I want to watch it and I want to hear it too. So if that is something that you guys are interested in, please let me know in the comments below, and I can certainly do lives. It's probably going to be like a 5-week trial, so it's going to really burn me out, but I'm going to be watching it anyways. So let me know either that, or I'm going to have to watch it and then give you recaps. So one or the other. I'll definitely be covering it. We have, I think we have another 1 or 2 pre-trial hearings, and then we're probably going to trial. So I'm not sure when the next date is, but when I do, I will let you guys know. And thank you so much for watching. I appreciate it. I appreciate your support on my channel. Thank you for the likes, the subscribes, any of it, all of it, the watches, all of it is great. And thank you so much. I appreciate it. It helps the algorithms. So it's much appreciated. And I just want to let you know that you are appreciated. So thank you. And on that note, I will let you go. So have a good one, and I will see you in the next one. Take care. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.